Thank you very much. So my topic, which I'm going to speak about and I would like to present today, is a proof of use of trademark in respect of goods and services concerned. So the proof of use, because the topic is really wide, if we speak about the actual use of trademark, and I would like to also last year when I heard the opinion of the participants of the seminar, judges, I wanted to make it a little bit more narrower. So this is the use of the trademark in respect to goods and services concerned. About my presentation, so I will have three subtopics which I would like to discover in this presentation. So, actual use of the mark with regard to services and goods, and the so-called Aladdin doctrine or test, as it is called. It has started from the judgment of the court, General Court in the case of Aladdin in 2005, wherein for the first time it was mentioned about this aspect. So the wide subcategory of goods and services. So then you can decide the proof of use of the trademark. So out of the whole range of goods and services for which the trademark has been registered, how do we decipher these subcategories and also the judicature of this doctrine or test? We should have made this wider for us to apply this. And the second, we will look at the criteria for objective and independent establishing of these goods and services. And the last will be as trends of legislation and also problem issues which we try to solve. And we will start with the first, and this is the actual use of the sign with respect to goods and services. And here we have to mark that there is in the regulation of EU trademark, there are these aspects are regulated, and also in the directives they are regulated, and also in national legislation. It is. So they have stated that there is no grounds to protect EU trademark or protect them against such a trademark which has been registered prior in exception with cases when this trademark is actually being used. And also what the General Court has stated, and they have worked on this rule for the use. So this 5 years ago, the registration can be abolished, so or it could be refused only. Only if it is used and the contested mark can be used on such a scope as the sign is being used, and this is also the mark is being used, and this is also in this slide starting. So we see mentioned these two cases, Anschul and Lamer, and where they say that trademark is being used correspondingly to its basic function. So I'm sorry, I do not have sound at all. The only thing I could do help to tell what I see on the screen. So it says that the relevance of proof for using trademark according to the directive is time, place, scope, and character. And so it is, and the character, meaning the trademark is being used in such a form as it is registered, and trademark is used with respect to the goods and services for which it is registered. And here we see Aladdin case.
Recording in progress.
If trademark is registered with respect to the category of goods and services, which is quite wide, and within its scope it could be objectively separated in divided in several subcategories and actually used and it covers goods and services with respect to the actual, and the proof of the use is sufficient. And if the trademark is registered with respect to goods or services that are defined or precisely and in a narrow manner, then within the respective categories, it is impossible to separate subcategories. The actual use should be assigned to the whole category. So and this we will see in the next slides. So the actual use of goods and services, Aladdin case, we speak about subcategories. Of course, here we see EU trademark regulation and national laws also stipulate and says that if the trademark is used for only one part of the services or trademark or services or products, then it should be not used or should be. So here we have the legal ground, and so this even if the marker oh. So NISA category titles provide us with a list of these groups, and in Aladdin case, the use of the trademark is very narrow, and it didn't allow to use the trademark as such because it had been registered for metal for treating metal, and this on the proof of the use of trademark with respect to the metal was only for this one means a cotton. So cotton makik, which is really only used for metal, and of course this can be perceived as just one means or detergent, and here. I'm sorry, it is real problem with the sound. When proof is available only on to such amount, and so when it is, which is included in the registration of the trademark, and the court decided that the Court of Appeal perceives the previous trademark as only very narrow, and it has been applied mistakenly. At that moment, regulation, as the regulation stated at that time, and then always this should be coordinated with the legal interests of the proprietor of the trademark. And also here, when establishing whether there are subcategories or whether the trademark should be made or this registration should be stopped. Or it should be revoked as such. It is whether it will interest to extend their range of services or products, and so taking into account that the system of trademark is not based on the use like it is in USA, and here it is possibility that when a trademark is being registered for a wider range than it is really used, and as the person would like to use at that moment, but in future it could be used for more products and services. But at the same time, we also have to take into account the regulation of and directive of the community trademark, which stipulates that in preamble of the proof of use is necessary to to reduce the number of those trademarks registered and protected, and to leave space for other trademarks to be registered, so that there's only one thing which is registered and used only for one purpose. So this balance should be taken into account when analyzing whether the use of the trademark is as it is registered, or there should be narrowing of the scope and evaluating these subcategories. And here we see that the next topic regarding criteria for establishing objective and independent subcategories of goods and services. And we come back again to Aladdin case, where with this judgment, court already established this criteria, which should be taken into account when making these subcategories, whether this subcategory division is grounded or not. So this is the use of the goods and also the object to be used. But as it was later stated in court decisions, these main criteria should be purpose of use and also the functional task of the goods and the services. And so here you see the analysis that this means for treating metal, they reduce actually the task of the goods, so it is just one part, and also as this also makes all the narrower. It is the treating of the metal with respect to the respective object, and so the metals, that is a category of goods which is included in the class 3 headline. This washing treatment and defattening and abrasive means. So here, so to say, to go so deep, so that to narrow this use only for one part, one very, very specific use of that product, where this use was shown, It is actually, I would say, artificial narrowing of the rights. So why is this category of product or a subcategory in this case, why this should be made separate, why it should be grounded, and why this trademark shows is very so specifically. If we see another case, if we historically from 2006, this is chronologically. So this case, Galcin, shows us how to establish these subcategories, applying those previously mentioned aspects, and here the trademark, which was being registered for pharmaceutical and medical preparations, especially preparations on the calcium base, and it was, and I have highlighted this especially. So this wording emphasizes those preparations on the calcium base. And this is just one of the examples and one of the groups, but the really use was only for those preparations on the calcium base. And the court decided that such a subcategory could be perceived as grounded, since these preparations are on the calcium base, and this is grounds for use of such a trademark only for those preparations which have a calcium base. And that is the very beginnings of this. Pharmaceutical preparations on calcium base about the purpose of use of products and also functional task. So here, this issue should be left open, or because the idea here was developed in the next one of the next decisions, where the court held that the purpose and intended use of the therapeutical preparation are expressed in its therapeutical indication. And this definition also included, definition employed should consider the goods in question are intended for the treatment these health problems. And then here the proof of the use of this trademark. Also, these are dosing aerosols which include corticoids and are issued only according to prescription. And here there is a basis to make a subcategory or subgroup, because these pharmaceutical goods, this is very wide category. It is a theoretical indication of this preparation of this product, and in this case there is also the question which we are going to discuss a little later in the end of this presentation. So why and who has grounds to request, or what terms are regulate making of such subcategory. So the party should prove. Should the second other party prove this, or it should be done by European Union, or as in case of this, or a Board of Appeal could make this ex officio, or who is that, or what is it institution which can make this subcategory, since the proof is much narrower than the registration. And here this use was admitted. These were preparations for breathing for respiratory therapeutical preparations for respiratory illnesses, and also this was admitted by the office since these criteria according to indications was grounded for, and you could use such subcategory, and we can consider that the trademark is being used as this is dosing aerosols at the same time. Also in this Respicure case and also in other cases where in this case, as you see in this slide, it was mentioned which factors cannot serve as a basis for making a subcategory. For instance, it is the active substance or dosing way or administering way of the preparation, or are they used in the hospital, or should there be doctor's prescription to buy these, or so, because these dosing aerosols are sold only by prescriptions. That is not a criterion to group subcategories for these aerosols. And also corticoids, this is the active substance for these aerosols, and this is for that respective treatment purpose. And so is this impossible to make an independent subcategory. And in the next case, which is quite recent, issue was about not about pharmaceutical preparations, but about a class 5 products, and what's going on when the use of the trademark is shown for several products, but at the same time when we apply the criteria which I mentioned before, it is impossible to consider that this cotton things are cotton is separate category, so we have to go into the group of the specific products which is included in the precisely defined category, which are binding materials, and also the use of this trademark is only for one specific group of the product. And there's different products and different services where this material is being used, and that should be taken into account. We have to take into account the specific sphere and for which this trademark is being registered.
And so the technical side here is Finnish ruling in 2018, where there's added that the criteria for the purpose of use, main purpose of use, it has to be the main purpose of use and not some kind of auxiliary aim of use. And so the sign that was for remote or mobile communication devices, the evidence was only about that this is a mobile recording device, and one of the examples. Usually for voice recording, if it's not a mobile device, but it is just for recording the voice or sound, then it shall not be a condition, or, well, they try to show that this is the condition of that such sound recording device, for example, allows for including or putting this recorded material, for example, sending it over to the internet, or publishing it on the internet using the computer, and it being as a, and so the party said that it is not, cannot serve for the basis as an auxiliary function for recording device, mobile recording device. this is not, it doesn't mean that it's an intrinsic function of the device itself. So it doesn't have a, well, it does have a common function with all the communication devices, remote or mobile. It's very broad definition for such devices, and indeed they do possess such characteristics. And this is believed in this particular time when the sign use was evaluated as objective independent category, which is a mobile sound recording device. And so there's grounds to believe that the sign was used for the whole broad group as communication devices. Also, this case is similar to the one we saw regarding the cotton, but the cotton and the 9 class says that if the registered in the database, the software is that use of it was shown in the modeling program and in communication, intercommunication between the companies. I don't even know what that actually means, but very specific description was then involved or a specific program related to the databases. So considering once again that there is some kind of very specific software, and if it cannot, so there have been examples, several examples, when the program is able to, and is linked to the database, then the database also approved that there is a basis to believe that the sign was really used for broader scope of meaning of category, and thus this principle that the owner of the sign, they cannot be asked to be proving that the sign was used in relation to all possible product variation included in the category. The category is defined sufficiently, and there is no possibility to be talking about subcategories, and there's a basis for this broader category existence. So this ruling of the court, as it says, the European Court of Justice, then this was decided after the General Court ruling, and very often it is being cited and referred to where the basic principles are reflected. We're talking about, and for the factual use of sign, these major aspects that need to be considered. If there is a necessity to quote, then this is the example, and also, for example, in the case of Aladdin, it can. So maybe this idea then is also very easy to comprehend, but it's not very technical. It is related to clothing, and also the use was shown, was reflected for various types of clothing. And hereby, with this example, then the significant aspect was that the claimant, there was an argument that the sign for various uses like conceal, protect human body, mask human body, that these are these various aims, and the court in this case gave their own answer that yes, there are several purposes and that we cannot consider, we cannot distinguish any separate, because it limits the rights of the owner of the sign. And so applicable evidence was regarding the clothing, which was included or precisely corresponds to the sign registration, included products, and so it was concluded that it refers to all the included products. Then there is this Grant Board decision, Grant Council, and rather easy to follow, but sign registration for the shoes was only proven for women's shoes, and it said that very much in detail it is analyzed what kind of criteria, is also mentioning that there are, it needs to be considered the purpose of use and functional purpose as also additional criteria, and the characteristics and the scope of the target audience. And very important is also the market reality, is that it allows to, well, once again, justify and divide, separate the category of women's shoes or children's shoes, and by analyzing all these aspects and the evidence what were in the case, the Court of Appeal then decided that the women's shoes is the separate or independent subcategory, and based on that these rights can be applied as for women's shoes, not shoes in general or footwear. So it does not have any implications maybe, but the question is is regarding the judgment of the product. So the result would be the same, but in any case these principles are applicable. And one fresh case, this decision, Testarossa case, was that the question was about very broad aspects about use of the sign, and at the same time trademark, and that the factual use of the trademark for particular services and products, and that it again refers to a very broad category of products, vehicles in its most broader sense, and applicable evidence only shows that, for example, there is a luxury vehicles only, or their parts, and that only in this regard it could be analyzed the factual use case, and that could serve as a grounds for, in a narrower sense, about the rights of the trademark. And then sports cars in themselves or in itself, we do not believe that it's an independent category of the vehicles. About, well, we can discuss whether it is so or not, but the question about luxury element, so whether narrowing such a thing subjectively, saying what is, or maybe is it very expensive or is it luxury, it's not actually a criteria or a reason to be narrowing the trademark owner's rights. Thank you. And this is a very fresh decision, the general decision of the court. Normunds, nezinu, tā nav. judgment, very interesting analysis about whether or not, for the medical purposes, and the proof was also presented whether there is a grounds or reason for narrowing based on the evidence or not. In this case, the court decided that there are grounds to believe that it was used in an explicitly defined supplements category. And there, then once again, if you are interested in this decision, you can then find out more about this category, subcategory, and analyze. And so the last case law tendencies and issues, is that it is stressed that there are tendencies mentioned that it is the responsibility to create a list of products and evidence and trademarks that are used in relation to the products and the services. So the attempt to register the rights then, and it can have, or it may have some detrimental effects. And the broader the term, the more you have to demonstrate the types of these products and services, whether we can maintain them in the scope of the registration. And if the trademark owner, only for the products and services that is believed to be independent, so factual use cannot be admitted for registration. And the thoughts are only about these questions and subcategory establishing and is it the responsibility of the party to defend, saying that not only the evidence has a more narrower principle and whether we believe that it is only related to the subcategory, which is narrower, broader category. So there's legal grounds that the instance, organization, or the office that is going to evaluate that, whether they have the right to indicate such category separately, so separate the category. So in our view, that once again, these both aspects are balanced always, and this is what we believe. Also, the Board of Appeal then has the right to separate the subcategory, even if the law does not require so. Thank you very much for the attention, and thank you for this presentation, for hearing, listening to my presentation.